or duty shall hold the appointment, unquote. Mr. Speaker, sir, following the termination of his appointment as chairperson of the board of the Financial Intelligence Unit, Mr. ST entered an action at the Intermediate Court against the state and the Prime Minister on 21st August 2018, praying for a judgment ordering the defendants to pay to him a sum of 1,092,000 rupees, representing payment for the unfinished term of his office as compensation for breach of contract, together with interest at the legal rate with effect from the date of the lodging of his plaint and with costs. On 16th of February 2022, judgment was delivered by the Intermediate Court, whereby the magistrate concluded that Mr. ST had established his case on a balance of probabilities and accordingly ordered the defendants to pay jointly to the plaintiff a sum of 1,092,000 rupees with costs. No order was made in the judgment regarding the interest claimed by Mr. ST. Being dissatisfied with the judgment of the Intermediate Court, the defendants appealed against the judgment to the Supreme Court. However, in a judgment delivered on 31st May 2023, the Supreme Court set aside the appeal but made no order as to costs. Mr. Speaker, sir, in regard to Part A of the question, the quantum of compensation payable would be 1,092,000 rupees as ordered by the court. However, insofar as the costs and interest elements are concerned, it would be up to the legal advisors of Mr. ST to seek to enforce the judgment. Once the legal advisors of Mr. ST take the necessary steps to enforce the judgment, the final quantum will be known to the defendants, that is, the state and another. At this stage, it is premature to state the exact figures. The honourable member would surely be aware that costs are also subject to taxation and may be disputed by the defendants. Mr. Speaker, sir, regarding Part B of the question, I am informed that payment will be made from Vote 23/1 of the Accountant General under Item 28217002 compensation arising out of government liability. Mr. Speaker, sir, it is to be noted that the court has not called into question the power of the appointing authority to terminate the appointment of Mr. ST. Both courts have agreed that the termination was done lawfully. As a matter of fact, in its judgment, the Supreme Court made the following observations, and I quote, "The learned magistrate rightly found that Section 28 of the IGCA applies to any appointment made under a specific enactment. And in addition, this right to appoint includes the right to revoke. We fully agree with this reasoning. As such, the President who had appointed the respondent had, by virtue of Section 28 of the IGCA, the power to remove, suspend, dismiss, or revoke his appointment at any time during the term of the contract," unquote. The honorable judges have further observed that, and I quote, "It is clear to us that, by virtue of Section 28 of the IGCA, it was always open to the President to put an end to the chairmanship of the respondent as chairperson of the FIU. The court in Jawaiya TD versus Dr. V. Jogu, 2017 Supreme Court judgment at page 71, adopted a similar view, and the learned judges held that since the applicant had been appointed by the Council, then by virtue of Section 28(1)(a) of the IGCA, the power to remove, dismiss, or revoke the appointment of the applicant devolves on the Council, unquote. Mr. Speaker, sir, the implications of the judgment of both the Intermediate Court and the Supreme Court will be examined, and appropriate corrective measures, if warranted, will be taken. Thank you.
Mr. Speaker, in the judgment of the Intermediate Court, the learned magistrate mentioned that the President of the Republic terminated the appointment before its expiration on the recommendation of the Prime Minister, without giving any reason. So it was the Prime Minister effectively who terminated the appointment. So being given that the Prime Minister is the one who terminated the appointment, doesn't the Honourable Prime Minister agree that instead of taxpayer having to pay for the consequences of his decision, he should be paying for the damages claimed as a result of his absolute decision to terminate the employment?
Well, if you read the law, and if you read it properly, you will see. I have quoted from the judgment of the Supreme Court. I'm not referring to the Intermediate Court. Supreme Court, because the case went on appeal. And if you read properly and carefully and take time, you will see that the judges say that it was perfectly lawful for the President of the Republic to terminate the contract of the chairperson. So take time, Honourable Member, and read carefully, and you will see. And secondly, if you read the law properly and if you interpret it properly, you will see that no reason is necessarily given when such termination occurs. This is by law.
I've read this, and I am a lawyer of much more standing at the bar, practicing at the bar, so I don't take any lessons from the Honourable Prime Minister.
Put your question.
The issue is very simple. The Supreme Court said that whereas the Prime Minister was entitled to ask the President to terminate the appointment, because he did so without giving any cause, before the expiration of the term, he has to pay damages, jointly and in solidarity, which means the Prime Minister personally has, together with the state, to pay those 1 million. So I'm asking the Prime Minister, as a man of honor, to take a commitment before this House that he's going to use his personal funds. So I'm asking him whether he's going to use his personal funds to pay.
You are requesting the Prime Minister to take his responsibility.
Well, the law, the judgment, so let me say that. The judgment say that the Prime Minister is jointly liable.
Bear with me. You're entitled for a question. Put the question and let the Prime Minister reply. If you have no question, Honourable, maybe prepare a question, I give the term. You have one. Put it.
The judgment of the magistrate, which has been upheld on appeal, state that the defendants, including the Prime Minister, shall jointly and in solido pay the plaintiffs the amount of 1,092,000. So the Prime Minister has been ordered by the court to pay jointly and in solido with the state of Mauritius this money. So I'm asking the Prime Minister whether he will pay that money or he will get taxpayer to pay for his mistake.
Well, Mr. Speaker, sir, first of all, I am not giving any lesson to this supposedly honourable member who claims to have... What are you, Kisasa?
Order!
They can...
Wait, order! 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 If there is anything wrong, you're entitled for a point of order.
He started, Mr. Speaker, sir, he started by saying, I am giving him a lesson, and he has been a longer standing member of the bar. So I am replying to this. So don't be a shark.
Order!
Don't jump like a shark.
The Prime Minister has a right to reply.
Yeah. So I am, Mr. Speaker, sir, Mr. Speaker, sir, I'm not giving any lesson. The honourable member has asked a question referring to the law and to the judgment, and I'm asking him to read the law, and you will see that I have quoted, and do I have to waste the time of the court, of the National Assembly again to quote what section 28(1) of the Interpretation and General Clauses Act say? It says that the one who has appointed has the right to terminate that appointment. The Supreme Court, both the Intermediate Court and the Supreme Court has confirmed this interpretation. That is, it is lawful for the President to terminate the appointment. And let me refer the honourable member to what was contended. What was contended by the plaintiff in the, before the court. And I quote from the judgment. The plaintiff contended that in terminating his contract with immediate effect, without giving any valid reason, the defendants committed a breach of contract. Now, the judges have said, and let me refer the Assembly to part of the what was found by the judges, the statement. Yes, and I refer to a paragraph where the judges found that the statement of the respondent before the lower court to the effect that the termination of his appointment was lawful is perfectly correct. And this could have only meant that the President was fully entitled to revoke his appointment by virtue of Section 28 of the IGCA. Why is he talking that the Prime Minister has revoked this appointment? This is what I'm quoting, and I understand English, that the President was fully entitled to revoke his appointment by virtue of Section 28 of the IGCA. However, the judges carried on to say that we do not agree that the respondent meant that since the revocation of his appointment was done in accordance with the law, this breach of contract could not entail legal consequences. And what are the legal consequences? The legal consequences is that the plaintiff is entitled to be paid compensation for the rest of the term of his contract. This is what I understand from the judgment of the Supreme Court.
Thank you, Mr. Speaker, sir. Can the Honourable Prime Minister confirm to the House that the same gentleman that we are referring to, Mr. ST, had several claims, among which a whopping amount of 19 million to the ICTA as legal fees, and whether the gentleman is actually related to any Honourable member? Thank you.
Well, yes, Mr. Speaker, sir. I can confirm that Mr. ST is the same person who had claimed and been paid in 2016 a total amount of 19,198,436 rupees as legal fees in the Supreme Court case of MTEL versus the Information and Communications Technologies Authority, Mauritius Telecom, and others. Mr. ST was also paid a sum of 3,314,895 rupees by ICTA, representing fees for legal services and retainer fees. Mr. Speaker, sir, it is publicly known that Mr. ST is the brother-in-law of Honorable Nankumar Buddha.
Thank you, Mr. Speaker, sir. Can the Honorable Prime Minister state the terms and conditions of the appointment of Mr. ST as chairperson of the Financial Intelligence Unit? Thank you.
Well, let me see. So I'm informed that Mr. ST was appointed as chairperson of the board of the Financial Intelligence Unit for a period of 3 years, with effect from 29th April 2015, with an all-inclusive monthly fee of 54,600 rupees. From the date of his appointment until the termination of his contract, Mr. ST was paid an amount of 873,600 rupees, representing his fees as chairperson of the board of the Financial Intelligence Unit. He was also paid an amount of 232,461 rupees, representing subsistence and entertainment allowance. The appointment of Mr. ST was made pursuant to Section 12(2) of the Financial Intelligence and Anti-Money Laundering Act.
Thank you, Mr. Speaker, sir. Since we are talking about termination of appointment, can Honorable Prime Minister inform the House whether there are similar cases of this kind where there is a claim for compensation? Thank you.
Mr. Speaker, sir, yes, I am informed that there is only one such case of termination under Section 28 of the Interpretation and General Clauses Act, where the plaintiff, a former chairperson of the Central Water Authority, is claiming compensation and damages for early termination of appointment.
Next question.
B743, please.
Mr. Speaker, sir, I am informed by the Commissioner of Police that the Mauritius Police Force has several units, branches, set up internally to offer the highest quality of service to the community whilst ensuring peace, law and order in the country. The main units are inter alia, the Special Mobile Force, the Anti-Drug and Smuggling Unit, the National Coast Guard, the Central Crime Investigation Unit, the Brigade pour la Protection de la Famille, the Special Support Unit, and the Traffic Branch. Bent on adapting to an ever-changing environment, the Mauritius Police Force has, over the years, adopted strategies to enhance the quality of its service to the nation. It has had recourse to foreign expertise to build capacity of the police officers and has developed media and communication strategies, acquired modern assets, and developed customer-friendly infrastructure. The police has also developed its strategic plan 2022-2025, which was launched on Wednesday, 19th of January 2022. The plan had identified 9 strategic priority areas to enhance the police force, namely improving service delivery, reinforcing community safety and partnership, tackling serious organized and transnational crime, enhancing investigative and operational capabilities, exploiting technology in policing, strengthening human resource management, managing disasters, building sustainability and resilience, and enhancing morale and motivation of police officers. Mr. Speaker, sir, I am also informed by the Commissioner of Police that as part of the Police Strategic Plan 2022-2025, and in order to maintain the momentum in the fight against crimes, including drug trafficking, The special striking team was set up at the level of the police headquarters on Wednesday, 3rd August 2022. The setting up of the units in the Mauritius Police Force is a prerogative of the Commissioner of Police, pursuant to the power vested in him under Section 71(4) of the Constitution, which reads as follows, and I quote, "Nothing in this section shall be construed as precluding the assignment to a minister of responsibility under Section 62 of the Organization, Maintenance, and Administration of the Police Force, but the Commissioner of Police shall be responsible for determining the use and controlling the operations of the force and, except as provided in subsection 3, the Commissioner shall not, in the exercise of his responsibilities and powers with respect to the use and operational control of the force, be subject to the direction or control of any person or authority," unquote. It is pertinent to mention that the Commissioner of Police, by the nature of his office, is a repository of classified and sensitive information which, on occasions arising, requires immediate attention. In the past, former commissioners of police had also set up similar units, such as the Flying Squad and the Special Anti-Robbery Squad, to which classified and sensitive information was relayed for prompt actions. Mr. Speaker, sir, as stated in the reply to private notice question on Monday, 12th of June 2023, the special striking team is not meant to replace or to substitute any other unit, but instead it complements the other adjuncts of the force in the fight against crimes. The main reason for the setting up of the team is to combat major crimes such as drug trafficking, money laundering, and other organized crimes. Similar to the objectives of other units, the goal of the special striking team is to improve the reactive capability of police through prompt responses to crime situations, thereby meeting the justified expectations of the community and providing a high level of service delivery. The main role of and responsibilities of the special striking team are as follows. 1, to conduct targeted intelligence-led crackdown joint operations with other unit or office, as well as other stations around the island, with a view to dismantling drug nexus, drug networks, and criminal activities involving association of malefactors. 2, to assist the anti-drug and smuggling unit, National Coast Guard, Police Helicopter Squadron, Asset Recovery Investigation Division, and officers of MRA and ICAC in the prevention and detection of important drugs and drug-related cases, such as drug dealing, trafficking, smuggling of goods, and money laundering, amongst others. 3, to support local police, divisional CIDs, Central Criminal Investigation Department in the arrest of habitual criminals and persons wanted in serious offenses or other offenses likely to cause disaffection, hostility among the population. And 4, to perform such other duties as may be assigned by the Commissioner of Police. Mr. Speaker, sir, in regard to Part A of the question, I am informed by the Commissioner of Police that the special striking team is currently staffed with 33 police officers. The team is under the charge of an officer of the rank of Assistant Superintendent of Police and is being supervised by the staff officer at the police headquarters, who is a superintendent of police. The team has been provided with 7 vehicles as well as with such arms and ammunition as are required for the discharge of their duties. In regard to Part B of the question, I am also informed by the Commissioner of Police that officers who are posted to the Special Striking Team are paid on a monthly basis the following allowances, which are in accordance with the approved rates prescribed in the PRB report 2021. 1. Risk allowance, 1,890 rupees. 2. Detective allowance, 450 rupees. Free clothing allowance, 505 rupees. And 4. A driving allowance for police officers in the rank of police constable and police corporal only. Members of the personnel of the Special Striking Team, irrespective of ranks, are also paid an ad hoc allowance of 2,000 rupees per month on the same ground as that of their counterparts posted to the Anti-Drug and Smuggling Unit. Thank you.
Yeah. In view of the fact that the SST has created a climate of fear because everybody feels that it can strike, we do not know where it can strike and whom it will strike, may I ask the Honorable Prime Minister whether special treatment is being given to that unit and whether that unit is above the law, taken into consideration the complaints, the allegations that have been leveled against that unit.
Mr. Speaker, sir, first of all, I don't see any climate of fear. The climate of fear, you know who are fearing this striking team? The criminals. Only those who are going against the law, and especially those drug traffickers, those who are involved in money laundering and in very serious crimes. They are the ones who are fearing this unit. Now, there's no special treatment. The question, I think the honourable member should have listened carefully to what I've said. They are being given allowances according to the approved rates that are prescribed by the PRB report 2021. And they have not been given any special privilege. Now, the honourable member is saying that they are going against the law. They are going above the law. Now, if anyone, not only I'm talking about this striking team, all police officers, and for that matter, anyone who goes against the law has to eventually answer before a court of law. So, nous sommes dans un état de droit. Et quiconque se sent lésé parce que quelqu'un a violé la loi ou n'a pas respecté ses droits, mais évidemment, il y a des autorités, ils peuvent faire ses complètes, et puis éventuellement, il y aura, si jamais besoin se fait sentir, il y aura une affaire devant une cour de justice. Et c'est la cour de justice qui va déterminer si effectivement quelqu'un n'a pas respecté la loi.
Thank
you, sir. Can the Honourable Prime Minister inform the House of the grades? That is, how many sergeants, how many inspectors are affected and constitute the Special Striking Team?
Well, Mr. Speaker, sir, the Special Striking Team is under the charge of an officer of the rank of an Assistant Superintendent of Police and is supervised by also a staff officer of police headquarters who is of the rank of a Superintendent of Police. The SST is also composed of 2 inspectors of police, 5 police sergeants, 1 police corporal, 19 police constables, and 5 women police constables.
Time over. Honourable members, the table has been advised that PQ B757 will be replied by Honourable Deputy Prime Minister. PQ B774 will be replied by the Honorable Vice Prime Minister, Minister of Local Government and Disaster Risk. Also, PQ B750 has been withdrawn. Honorable Member, the Honorable Vice Prime Minister, Minister of Education, Tertiary Education, Science and Technology, has made a request for parliamentary questions addressed to her be taken out of turn, since she has to leave the Assembly earlier today to enable her to leave Mauritius early this afternoon to proceed to India to attend the G20 Education Ministers meeting. I have acceded to the request. I'll call the Honorable Ganga Prasad, B785, to put his question.
Mr. Speaker, sir. B785.
Mr. Speaker, sir, I'm informed that 55 pupils in 35 pre-primary schools and 2,581 pupils in all primary schools have been identified as having learning difficulties and disabilities. As at date, there are 71 learners with special education needs attending mainstream primary schools. Furthermore, 11 integrated units set up in primary schools and special education needs resource centers are presently accommodating 117 learners with disabilities. My ministry has taken significant measures to support children with special needs in pre-primary and primary schools. Our approach is multifaceted and encompasses various aspects, including identification, intervention, early support program, and teacher training. Allow me to outline some of the key measures that have been implemented. A comprehensive system has been implemented for the early identification of learning difficulties and disabilities at the level of the school. We have the developmental learners profile at the pre-primary level and the primary school readiness at the primary school level, which are administered to determine the learning gaps in numeracy and literacy. A multidisciplinary team consisting of speech therapists, educational psychologists, occupational therapists, and physiotherapists conduct a screening to determine the best educational placement and accommodation required for each learner. For each student identified with learning difficulties, an individualized education plan or a personalized education plan is developed. The IEP and the PEP serve as a roadmap to outline specific goals, accommodations, and modifications tailored to meet the student's unique needs. It ensures that appropriate interventions and support are provided in a personalized manner. Public schools have trained support teachers, teaching assistants, and carers who provide targeted support to pupils with learning difficulties and disabilities. The early support teachers and teacher assistants work closely with classroom teachers to implement strategies and interventions outlined in the IEPs and the PEPs to facilitate and improve the performance of the pupils. Additionally, a number of measures have been implemented at the level of my ministry for the provision of pedagogical facilities for learners with learning difficulties and disabilities as follows. Adapted textbooks are provided, provision of braille displays for visually impaired learners, assistance of a reader or writer during examinations, assistance of sign language interpreters, large prints for examinations, provision of extra time as well. Mr. Speaker, sir.
Mr. Speaker, sir, may I ask the Honourable Minister whether in line with the Special Educational Needs and Disability Code of Practice and the Westler Intelligence Scale for Children 4th edition, which are applied in countries like UK, South Africa and India to identify learning disabilities and learning difficulties respectively, she will inform the House how many educators, carers, support teachers in pre-primary and primary schools have been duly trained in psychometric and neuropsychology to evaluate our children.
Mr. Speaker, sir, the medical directorate of my ministry, the Health and Wellness Directorate, has got doctors, and we work in close collaboration with the Ministry of Health for that particular purpose. But I must also say that as far as training is concerned, we have been training 464 SEN educators during the past month, and the training is still on. We are still having recourse to our resource persons from abroad for that.
Mr. Speaker, sir. Will the Honourable Minister inform the House what measures, if any, are being taken to ensure that psychometrists and neuropsychologists have proper and adequate assessment tools to support the system and the concerned children by providing them appropriate and accurate evaluation tools and facilitative educational interventions?
Mr. Speaker, sir, the Special Education Needs Authority and the SEN unit of my ministry are working with the children, their parents, and also, as I've stated earlier, with professionals from the health sector to help them do that. Furthermore, we do have some resource persons who come from Ireland for neuroscientific development of our children.
B788, please.
Mr. Speaker, sir, in the context of the internationalization of the Mauritian higher education sector, institutions are encouraged to enroll foreign students. The academic requirements applicable to foreign students for enrollment in higher education institutions in Mauritius for a university program leading to a degree are as follows. They should have either 3 subjects at A-level and 1 subject at subsidiary level at the high school certificate examination, or 2 subjects at A-level and 2 subjects at subsidiary level at the high school certificate examination, or 3 passes at A-level. They can also be, some of them also have relevant diplomas and national diploma from recognized institutions, and these are the requirements for their admission. Foreign students may enroll on full-time and undergraduate programs. For postgraduate programs, foreign students possessing a degree may enroll for both full-time and part-time courses. They should also be holders of a student's visa. I am informed by the Passport and Immigration Office that application for student visa should be made by the institutions having enrolled the students. Mr. Speaker, sir, with regard to Part B of the question, I am informed that a total of 1,666 foreign students have enrolled in public and private institutions since January 2022 to date.
May I ask the Vice Prime Minister whether there has been a fall in the number of students enrolling since January 2023?
No, Mr. Speaker. This is not the case because we have students getting enrolled at different points in time during the year. So some institutions have admission in March, others a bit later. So there hasn't been a fall as noted.
I'll ask another question, Mr. Speaker, sir, whether the Vice Prime Minister is aware that there is a change in the entry visa policy, and which has become more stringent so that we have less and less students coming to Mauritius?
This is not the case, Mr. Speaker, sir. However, the PIO has noted that there are certain candidates who had submitted certain fake documents, and they are investigating on that issue, and that is why they had to be more careful while providing the permits.
Yes, thank you. B799.
Mr. Speaker, sir, I'm informed that on the 6th June 2023, the presence of bugs at the Ranganathan Srinivasan State Secondary School was reported to the Port West Health Office. Following a survey conducted by the Vector Biologist Control Division of the Ministry of Health and Wellness on the 7th June 2023, a spraying exercise was carried out the next day in the whole school. Upon advice of the health authorities, the school was closed on the 8th and 9th June 2023, and a general cleaning of the school was effected on Friday 9th June and Saturday 10th June 2023. On Monday 12th June, bugs were again detected in 4 classrooms. Accordingly, arrangements were made for disinfection of these 4 classrooms. I'm informed that another exercise of spraying of insecticides will be carried out for the whole school by the 3rd week of June, and a 3rd session of spraying has been scheduled on the 7th July 2023. My ministry is also planning to extend the insecticide spraying exercise to all schools, especially those in areas which are more prone to infestation due to climate and to climate conditions.
Speaker, sir. I've read the analysis made by Mr. Arvind Bhajan, President of UPSI, in the light of the problem that happened at Anganadan Srinivasan State Secondary School. And he says the problem will persist because the desk and the chairs are very old and they harbor bugs. Can I ask the Honourable Minister whether mere spraying can be a solution or the whole furniture must be changed in the course of time?
Mr. Speaker, sir, have to depend on the advice provided by the health sector and by the people over there. In case the furniture is really bad, we will need to replace. But as for now, all I've been advised has been, all advice we have received has been for the spraying and constant spraying and monitoring of the situation in the school.
Similar problems were found island-wide, again by the request made by Mr. Arvind Bhajan. Can I ask the Honourable Minister whether it can be envisaged during each school holidays, just prior to commencement of classes, to have this disinfection exercise conducted routinely under the supervision of the headmaster or the rector?
Mr. Speaker, sir, this is what we do normally. Before school re-entry, we have a school readiness program, and heads of schools are supposed to do all that. But as I've just stated in my reply, we are planning to carry out an extensive spraying exercise in all our schools during the holidays.
Honourable members, the Honourable Deputy Prime Minister, who is also proceeding on mission abroad, has requested his question to be taken out of turn, so I'm acceding. I will now ask Honourable Fukyun to put a question. B757.
Mr. Speaker, sir, it is estimated that some 100,000 households derive income directly or indirectly from the travel and tourism sector in Mauritius. As for direct employment, I'm informed by Statistics Mauritius that a survey of employment and earnings is carried out on a yearly basis among large establishments employing 10 or more persons in the tourism industry. These establishments operate in the food service, hotel and travel sectors, as well as other services, including air transport, tour operators, travel agencies, and car rental companies. According to the results of the said survey, total direct establishment in large establishments of the sector was as follows. 2019, 31,550 employees, of which 440 non-Mauritians. 2020, 32,253 employees, of which 744 non-Mauritians. 2021, 27,858 employees, of which 569 non-Mauritians. And 2022, 27,626 employees, of which 1,046 non-Mauritians. Corresponding figures for the period January 2023 to date are not as yet available. As regards the vacancies in the tourism industry, I'm informed by the Human Resource Development Council that as at date, the estimated vacancies in the tourism and hospitality sector range between 3,590 and 3,890. Mr. Speaker, sir, with regard to Part B of the question, I wish to inform the House that a joint working group comprising representatives from both the public and private sectors has been set up under my chairmanship to formulate recommendations to ensure the sustainable, inclusive and resilient growth of the tourism and hospitality industries. The presently applicable policy relating to employment of foreign labour in scarcity areas dates back to 2015. New policy proposals are under discussion at the level of my ministry in consultation with the Ministry of Labour, Human Resource Development and Training, and the Ministry of Finance, Economic Planning and Development. Moreover, the joint working group bringing together relevant stakeholders of the public and private sectors has set up a subcommittee on talent management which will formulate recommendations pertaining to attractiveness, recruitment, training, retention and career development within the tourism and hospitality sectors.
L'honorable ministre, peut-il nous dire combien d'employés de l'industrie du tourisme ont été licenciés pendant la pandémie de la COVID-19 et combien de ces employés ont été rembauchés par cette même industrie par la suite?
Mr. Speaker, I would have been delighted to provide such information had the question been put. I think the standing order is very clear, the relevant standing order 26, that the purpose of supplementary question is to elucidate information requested. So if the Honourable Lady would put a question on the next occasion, I shall be happy to try and find the required information and provide it to the House.
Je suis certaine que l'honorable ministre sait pertinemment que la force même de notre industrie touristique est la particularité de notre personnel mauricien. Comment l'honorable ministre a l'intention de retenir et d'attirer les Mauriciens et les Mauriciennes pour travailler dans cette industrie, surtout que beaucoup de pays étrangers recrutent la main-d'œuvre mauricienne de cette industrie?
Mr. Speaker, I just explained, and maybe I should repeat yet again, that right now there is a joint public-private working group with a specific subcommittee set up to formulate recommendations concerning attractiveness, recruitment, training, retention, and career development for employees within the sector. In parallel, my ministry is consulting the Ministry of Labour and the Ministry of Finance to review the present quota policy pertaining to foreign employees.
Thank you. B784.
(758), perhaps?
758.
Yes, thank you. Mr. Speaker, sir, I am informed by the NSLD that 24 officers are to be recruited, of which 16 will be directly involved in the monitoring of the construction of the 8,000 housing units, which represent the first phase, of course, of the project.
Yes, thank you. This is a huge project, and being given that, and they are very complex because it is a design and build contract, meaning the contractor is the paymaster to the consultant. Can I ask the Honourable Minister, being given that the CEO and COO of the NSLD are not from the construction industry, who is in charge of conducting the interviews of these new recruits in such a way that we have competent people who are costauds, I say, to supervise this huge construction site project, 8,000 housing units?
Mr. Speaker, sir, I do not run the NSLD. If the question is put next time, I'll provide the information. What information I have at hand, and I will provide it, is that the 16 officers comprise project officers, project assistant, technical officers, project administrative assistants, and I will agree that with the Honourable Gentleman that we face a huge challenge because with the design and build mode, it will be up to the NSLD to provide monitoring of compliance with time, quality of construction, and a host of other issues. So yes, it is a complex exercise, but unfortunately I do not have the composition of the interviewing panel, and I'm sure the Honourable Gentleman will understand that.
Can I suggest to the Honourable Minister to get the technical ministry, which is the infrastructure division of the Ministry of Public Infrastructure to at least assist in the interviews being conducted so that we get the best competent people to supervise.
Because I thank the honourable gentleman for the suggestion.
Thank you.
Honourable Buddha.
E759, sir.
Yes, Mr. Speaker, sir, I'm informed by the NSLD that 400 housing units will be constructed in constituency number 16, Vaquen-Floréal, as part of phase 1 of the project for the construction of 8,000 housing units over a period of 18 months as from date of award of contracts. Now, in addition to these 400, I stand informed that 64 housing units will be constructed by the NHDC in the same constituency, and the construction of these units is expected to be completed by mid-2024.
Deputy Prime Minister, where these new estates are going to be implemented?
As regards the NSLD, I understand all 400 will be located at Camp Mapu, albeit on 2 distinct sites, whereas the NHDC housing units are to be built at Henrietta and Glen Park, respectively.
The question? Yes, thank you. In view of the fact that we already have 2 estates of about 400 units which have been constructed in that region in the recent years, the fact that we are adding another 500 more units, can the Honourable Deputy Prime Minister consider what are going to be the accompanying amenities, because that is going to be about 3,000 more people coming to that area in Oyeta, whether accompanying amenities are going to be considered, and if they are going to be considered, what are they going to be?
Certainly, Mr. Speaker, I wish to assure the honourable gentleman that government shares his concern. Land is scarce. State land is even more scarce, and he knows fully well that within that constituency there aren't that many locations where state land is available. Now, for the NSLD project, the only appropriate site is in the region of Camp Mapu. As the honourable gentleman in the House is aware, for all new projects now, both of the NHDC and NSLD, various community facilities are being provided, from children's playground to jogging tracks, community halls, specific areas, buildings for a shop or 2 shops to be set up, a dedicated taxi stand. We have requested that there be one of the families of the complex, that one person from the residents holding a taxi permit. We're looking at bus stands, reviewing bus routes, considering accessibility to schools for school-going children, to healthcare facilities, area health centers, for instance, or hospitals, the social security officers for seniors in the community. So yes, we are looking into a host of accompanying measures, because it is indeed a challenge, and I've never concealed the fact that this whole project is historically unprecedented and will require even more attention to make sure that proper community living is provided for. And again, any suggestions from the honourable gentleman would be most welcome. As regards the NHDC, I understand that a number of apartments will be built just behind the existing NHDC complex at, ça c'est NSLD, behind that, the NHDC complex at Camp Mapu. For the NHDC, 47 units close to Résidence Iris at Henrietta, and then 17 other apartments at Glen Park. So there again, we will be making sure that by adding more families, more households to that same area, the opportunity is taken to upgrade, as and where necessary, facilities for the community.
Honourable members, I'll suspend the sitting for 1.5 hours.